Good evening, all. Welcome to another educating lecture in our series of Family Court Judge Exams 2023. On behalf of Bar Council of Maharashtra and Goa, I welcome the Chairman, Vice Chairman, other members of Bar Council of Maharashtra and Goa, and our resource person for today, Dr. Professor Dinesh Kolte. I am privileged to take you all through few of his strengths. Sir is holding a gold medal in LLB from MP Law College, Aurangabad in the year 2002. He has achieved his LLM in constitutional law in year 2004. He holds net set degree. He has completed his PhD in law in year 2021, and since 2022, six students registered for PhD under him. Sir has a teaching experience of 18 years and he is working as professor of law at MP Law College. He has guided 60 students for LLM dissertation and published more than 30 research papers. He has been faculty for judicial classes and around 170 judges have taken guidance under him. I request Sir to start his guidance lecture on the topic of presumptions under Evidence Act with reference to matrimonial law. Over to you, sir.
Thank you, madam. Whether PPT is visible? Thank you, madam.
Yes, sir. Yes, sir.
Yes. Whether the meeting is being recorded by you or someone else?
Yes, it is.
Yes,
It is recorded by Bar Council.
Okay, thank you. Thanks. Good evening, friends, and all the respected members of the organizing committee. It is my privilege to deliver a lecture to you on the topic of the presumptions. Yesterday, I got a call, and within a short span of time, I am going to deliver the lecture to you on the topic of the presumptions under the Indian Evidence Act with special reference to matrimonial laws. The friends, what is a presumption? Here, presumption is defined as an inference. Now, what is the difference? Presumption and burden of presumptions and evidence. What is the difference in it? Whether the presumption is a substitute to the concept of evidence, to some extent it is true. Now, what is the presumption? Because when we study the outline of the CRPC, there we come to know that there are certain things, they come under definition of the evidence, but certain other things they do not come under definition of the evidence. Because when the court comes to the conclusions, and when the court decides any fact whether it has been proved or disproved, as per section 3, we study three concepts: proved, disproved, not proved. And in proved, disproved, not proved, there the legislature has used the word matters. Means as per the definition of the proof, a fact is said to be proved. A fact is said to be proved when court, after considering the matters before it, the court either believes it exists or considers existence of a provable matter. Means what does it mean? Means here, when the court comes to the conclusion whether any fact has been proved or not, means the court not only relies or take into consideration the evidence oral or documentary, but other matters. Here, this definition gives the wider meaning. Means court not only rely on the oral or documentary evidence, but in other matters. What are the other matters? Means those are things which do not come under the definition of the evidence. The court also consider them I give the example to you about admissions, confessions, presumption, adverse inferences. These are nothing but these are not evidence. But even though, in order to arrive at the conclusion, the court consider all these things. Now, therefore, sometimes what I say that presumption is a substitute for the evidence sometimes. Now, here, what is the definition of presumption? Now, generally, we take the meaning of the word presumption here in our colloquial transactions. Means we presume something. A boy and a girl, if they are talking each other's, immediately people draw the presumption against that. But here, in we are studying the law. The Indian Evidence Act deals with a certain concept. There we should not put it. Okay, now here see presumption. Again, when we are going to study this concept, there is a correlation between the presumptions and burden of proof. Now here, what is the presumption first? Presumption is defined as an inference. It is an inference, it is a conjecture drawn by the code. Who draws? It is drawn by the code. On what basis it is drawing? On the basis of reasoning from one fact or set of facts as to the truth or falsehood of another fact. Then again, James Gibbon, who drafted the Indian Evidence Act, he wrote books, Digest of Law and Evidence. And in that book, he has defined the definitions of presumption. What he says, presumption is the rule of law. And these are the rule of law. See, in a Indian Evidence Act, you find so many rules are there, wherein the court has to presume that fact. Therefore, Sir James Gibbon says, presumption is a rule of law. That courts and judges shall draw a particular inferences from a particular fact or from particular evidence, unless and until the truth of such an inference is disproved. James Gibbon, who drafted the Indian Evidence Act, he defined the definition of presumption. Says that presumption is a rule of law. That courts and judges, who draw the presumption? Courts and judges, not you and me. And shall draw a particular inference from a particular fact. From a particular fact, the court draw the particular inference. And again, see, this says the presumption is reputable. Though the court presume that fact, but here the James Gibbon has used the word unless and until the truth of such an inference is disproved. So this is the definition of James Gibbon. Then here about Chief Justice. Here also defined the definition of presumption. Presumption of any fact is properly and inferring of that fact from other fact. Means we presume a fact, we presumption of any fact is properly and inferring of that fact from other fact which are known. Means we draw the presumption from the other fact. What is said the above said. Then again, Best, who is a jurist, British jurist, again he defined presumption. And he is the first person, friends, he defined that presumption, there are two types of presumption, positive presumption and negative presumption. What he says here, an inference, affirmative or a disaffirmative. See, there are certain sections in Indian Evidence Act. Means there are two types of presumption, positive presumption and negative presumption. There are certain sections. See section 114A. See section 105. These two sections deals with the negative presumption. Therefore, your best says that a presumption is an inference. Affirmative means positive or a disaffirmative negative of some fact drawn by judicial tribunal means court by process of probable reasoning. Because we from the reasoning we draw the court draw the particular presumption, and that is a presumptions of from some matter of fact. These are definitions given by the best. And your best has covered there are two types of presumption, positive presumptions and negative presumption. Now here again, Sarkar, who is an author, Indian author, where he has written the books on the law of evidence and other subject. What he defined the definition of presumption? Presumption is an inference of fact. It is inference of fact drawn from other known or proved fact. Now, presumption is an inference of fact. We draw it from the known or proved fact. See, in order to understand the concept of presumption, one should go through the sections 114 of the Indian Evidence Act. Section 114 is the best section to understand the presumption. Now, here, he gave the example that if a man is found in possession of goods soon after the theft, see the illustration first of section 114, he has given in his definition that if a man is found in possession of goods soon after the theft, he may be presumed to be thief. He may be presumed to be thief. Means this section 114 says soon after the commission of the theft, a person who find in possession of stolen article, then section 114 says the court shall presume that he has stolen that article or he possessed that article knowing to be stolen. Okay? Or he might have purchased it by knowing that it is stolen article. Either he is thief or he is the receiver of the stolen property. That we have to draw it presumption because soon after, see the phrase, soon after the commission of the theft, he is found in possession of the stolen article. Then presumption is he is either the thief or receiver of a stolen property. So this is the Sarkar defined it. Then now, friends, there are two types of a presumption: presumption of fact and presumption of law. Presumption of fact and presumption of law. The presumption of fact is called natural presumption, and presumption of law is called as a artificial presumption. Artificial presumption. Now, what is the presumption of fact? In brief, I will tell you, is a presumption that is drawn by the court. Now, in Indian Evidence Act, who draws the presumption court? And which it thinks likely to happen regard being had to the common course of natural events. What is the natural events? Human conduct. Take the example what is happening in Himalaya. If the snow melt, then we feel the cold wave. Then cold wave comes. Then we say that ice is melting there in Himalaya. Therefore, there is a cold wave. That is natural events. Means how can we draw this presumption? It says common course of natural events. If somewhere it is raining and if there is a flood to any river, we say that somewhere it rains. Then natural events. Then human conduct. What is the human conduct? Suppose a boy and girl live in one room. Previously, people presume them they are the husband and wife. See section 49 or 50 of the Indian Evidence Act. Section 50 of the Indian Evidence Act. Human conduct. Maybe from the human conduct, we presume or assume any fact. Public and private business. Suppose I post a letter in the post office and if with a correct address, and if it doesn't return it, what do we presume? That it has reached to the addressee. So this is a presumption, public and private business, in the relation to the fact of the particular case. Means on what presume? The court presume the presumption of the fact. Then again, this presumption of fact is called natural presumption, are inferences which are naturally and logically drawn from the experience and observations of the course of nature. Means presumption of fact, it is based on it is drawn from the logic and from experience and observations of the course of nature. So that we have studied here. Then again, they have given the example. Now see, next the presumption of law. Now these are the arbitrary presumption. Means here, what is the arbitrary? It is made mandatory that there the court has to presume that fact. See, what is this presumption? Presumption of law, these are the arbitrary inferences which the law directs the court to draw from particular facts without regard to the logical inclination of the mind. First, I told you that there are two types of presumption. One is the presumption of the fact and presumption of the law. See, presumption of fact is called a natural presumption. They are drawn on the basis of the logic and from the experiences and observations. Now, presumption of law does not drawn from the logic and observances, but the concerned law directs that that court has to presume that fact. Now take the example. These are arbitrary inferences which the law directs the court to draw from particular fact without regard to the logical inclinations of the mind. See, in a presumption of law, the court does not have discretion. The court cannot apply logic because the law has directed that there the law has directed under concern section there the court has to presume that fact. The court does not have any choice, option, or a discretion. So this is a presumption of the law. There is a third concept, the mixed presumption. Again, the presumption of law, there are two types of presumption of law. Absolute presumption. Absolute presumption means where we can't rebut it. We can't rebut it. And in partial presumption means where see in a map shall presume and conclusive proof. These are the presumption of law. And out of them, conclusive proof is the absolute presumption wherein you can't rebut it. But in the case of the, see, in the case of the partial presumption, it is rebutable. Take the example, shall presume. It can be rebutable, it can be countered, it can be disproved. So these are presumption of law and presumption of fact. The presumption of fact and presumption of law, there are two types of presumption of law. One is the absolute presumption, another partial presumption. It means conclusive proof comes with the absolute presumption wherein party can't rebut it, can't disprove it. So in brief, I have prepared the one chart about the presumption. What is the distinction between presumption of fact and presumption of law? See here, presumption of fact is based on the logic. It is not based on logic, but it is a provisions of law. That presumption of fact is always rebutable. And once we rebut it, it goes away. Whatever you presume something. Always rebutable and goes away when rebuted by establishment of positive. Now just take the example, suppose the boy and girl talk to each other. The friends of that boy, they think about it that he's in love with any girl. Then they tease him. Then inform you that what do you think? That she is not my beloved, but she is my sister with whom I was talking. Then he rebut it. What do you say? Presumption of fact is a rebutable and goes away when rebuted by establishment of the positive. Again, presumption of law. I told you there are two types of presumption of law. One is the absolute, means if it is a conclusive rule, which we can rebut it. Okay, that is this we are saying. Then presumption of fact is uncertain. What is uncertain? Means here, in a presumption of the fact, the court has a discretion. The court has a choice. The court has a discretion choice option to presume or not to presume. But in presumption of law, the court does not have the choice. It is a mandatory on the court to presume that fact. To presume that fact. I discussed with you about this concept. Now I had told you the jurist best define the definition of presumption, positive and negative. Now I prepared the one chart here. Presumption, positive, negative. Positive means affirmative or negative. See, may presume, shall presume, conclusive rule. These three concepts comes under the positive presumption. Then negative shall presume. And I told you there are two sections in Indian Evidence Act. These two sections deal with the negative presumption, section 105 and section 114A. Okay? While teaching you, then you will understand all these things. Yeah. Now presumption. Now presumption of the fact and presumption of a law. So there is a problem to my voice because I am not feeling well. But as a Varanjikar sir and Rajendra Ragule sir asked me to deliver lecture, therefore within a short span of time I am delivering lecture. Though my voice is not clear as I require. Now see presumption. There are two types of presumption: presumption of fact and presumption of law. Okay, whether my PPT is visible, madam?
Yes, sir.
Yes, okay, thank you. Now see, presumption. First, we have studied the definition of presumption. Then types of presumption. Then presumption of fact, presumption of law. Now we are going to see here the chart through which we will understand the presumption of fact, presumption of law. Then rebutable presumption, may presume is a rebutable presumption. And in these sections of the Indian Evidence Act, they have used the word may presume. Then presumption of law, rebutable, irrebutable. Just I told you, there are two types of presumption of law, absolute and partial. In absolute means which we can't rebut it. And partial means we can rebut it. See here, presumption of law, rebutable shall presume. And in these sections of the Indian Evidence Act, they have used the word shall presume. Okay? Then irrebutable. Irrebutable means which we can't rebut it, which we can't dispute, which we can't counter it. And conclusive proof is the example of the irrebutable presumption. And friends, under these three sections of Indian Evidence Act, the word conclusive proof has been used. Section 41, sections 112, sections 113, and section 82 of the IPC. These sections deal with conclusive proof. So this I made the chart. I made another chart. Now see here, presumption, rebutable, irrebutable. See, may presume and shall presume. They are rebutable presumptions. Okay? Irrebutable presumption, conclusive proof. These are the sections. I hope you understood it a little bit about this concept. Now, friends, we are going to study the may presume. See, section 4 of the Indian Evidence Act defines three concepts: may presume, shall presume, conclusive proof. Now, see the definitions of may presume. Now, see the definition of may presume. Okay. Now, here, what is the may presume? And I told you the may presume comes under the presumption of the fact. Shall presume and conclusive, there comes in the presumption of the law. Then we have studied the difference between presumption of the fact and presumption of the law. Now here, see here, may presume whenever it is provided by this act. Whenever it is provided by this act, see here, whenever it is provided by this act had provided. It means whenever they have used the may presume in this act. Wherever you find the word may presume in this section, there the court has. Whenever it is provided by this act, that the court may presume a fact. Here that the court may presume a fact. What is a fact? We have studied in section 3 of Indian Evidence Act. What is the fact? There are two types of fact. See, physical fact and psychological fact. Anything, state of things, relation of things, capable of being pursued by the senses. The thing which we pursue by our five senses, that is called the physical fact. The thing which we pursue by our five senses, that is called the physical fact, that is called the external fact. Then clause 2 of the definition of fact defines psychological fact. Any mental conditions of which any person is conscious. Now say any mental condition of which any person is conscious. Now that is called the state of mind. There are certain offenses wherein the prosecution has to prove the state of mind of the accused. Friends, as per the section 3 defines the definition of the fact. There are two types of fact: physical fact and psychological fact. Okay? Again, relevant fact and fact in issue. Okay, now here, whenever it is provided by this act, the court may presume fact. Which fact means? The fact in issue, this fact. The court has to presume that fact. What court has to presume that fact? What court has to presume that fact? See that the court may presume a fact. Now here, see, I hope you understood whenever it is provided by this act. It means, jahan pe bhi, wherever, in Indian Evidence Act, wherever they have used the word may presume, the section in which they have used the word may presume, there the court has that the court may presume fact, it may either. Now there is the word it may either. What is it may either? It may either regard such fact as approved unless and until it disproved, or may call for proof of it. May call for proof of it. Now, friends, see, in a may presume, the court has a discretion. The court has a choice. The court has an option to presume or not to presume. Presume or not to presume. If the court presume that fact, then see what happens. If the court does not presume that fact, what happens? Therefore, I am telling you the correlation between presumption and burden of proof. Presumption and so we are going to study presumptions and burden of proof. So presumption and burden of proof में क्या फर्क है? What is the difference in it? Now here see, wherever it is provided by this act that the court may presume a fact, that the court may presume fact, it may either say it may either here the court has see in a may presume it is based on the fact, it is based on the logic, and in a may presume the court has a discretion because the language see the language. It may either regard such fact as approved unless and until it is disproved, or may call for proof of it. Now here, in a may presume, the court has a discretion. Court has a choice. The court has an option to presume or not to presume. What is the presume? Presume that it regards such fact as approved. Okay, what is the presume? It may either regard such fact as approved. What fact as proved? That one person has stolen the mobile of others. This fact has been proved. Now I will give the example. Suppose take the example. Take the example. Take the example. Suppose one person stolen the mobile. I taught you section 104. Just we discuss section 114. In section 114, there they have used the word soon after the commission of the theft. If a person is found in possession of a stolen article, it may presume that he is either the thief or receiver of the stolen property. Now, what means if the court presume that fact, that he has stolen that mobile, he has stolen that article, it means there is no need, when the court presume that fact as approved, means there is no need there is no need on to the prosecution to prove that fact by bringing evidence. Means see, as per the burden of proof, in a criminal case, as a general rule, burden of proof always lies on a prosecution in a criminal case. Initial legal burden of proof lies on the prosecution. But what I said, when the court presume that fact, when the court presume that fact as approved, then the burden of proof does not lie on that person on whom the court presume that fact. Okay? See, what is the correlation between the presumption and burden of proof? If the court presume that fact, then initial legal burden does not lie on the prosecution, then the burden of proof lies on that person against whom the presumption is owed. And that is a reverse burden of proof. He has to reverse it. Just take the example. In order to understand any concept, I give a simple example because you are well versed with the Bollywood actors and actresses. Suppose there is a marriage of the Katrina Kaif, and Salman Khan attend that marriage. And what happens? Her mobile has been stolen, and that was found in the possessions of this Salman Khan. So, what is presumption as per section 114? That Salman Khan might have stolen it. If the court presume that fact that Salman Khan has stolen it, then there is no need to the prosecution. Then burden of proof, initial legal burden of proof will not lie on the prosecution to prove that fact. Okay. Then on the contrary, the person against whom the presumption is held against Salman Khan, as soon after the commission of theft, you found the possessions of the mobile of the Captain, okay, you are the thief. Now you have stolen it. This fact has been proved. If the court presume that fact as a proof, then initial legal burden which lies on the prosecution will not lie on the prosecution. On the contrary, the reverse burden of proof will lie on the person against whom he presumed. Now here the court presumed that fact. Which fact? That Salman Khan has stolen the mobile of the Katrina Kaif. This fact has been proved. If the court presumed that fact, then the initial legal burden, as usual, lies in a criminal case on the prosecution, will not lie on the prosecution to prove that fact beyond reasonable doubt. On the contrary, the person against whom the presumption is held, the reverse burden of proof will lie on him. Okay, and what he may say, no, I haven't stolen it. I purchased it in the market by paying the fees. This is the if he explained it. See, he may show the receipt, and through the receipt, then he may disprove it. That no, I purchased it from the market. One thing, and through by paying the proper payment. See this bill, we show the proper prices there. Therefore, whatever presumption we have hold against him, he disproved it. So what I am telling here, in a may presume, the court has a discretion, may presume, may not presume. If the court presume that fact as a proof, then in a criminal case, as a general rule, the burden of proof always lies on the prosecution. It will not lie on the prosecution. On the contrary, the person against whom the presumption is held, the reverse burden of proof will lie him to disprove that fact. Okay, so here in may presume, the court has a discretion, choice, option. It may either regard such fact as a proof unless and until it is a disproved, or may call for proof of it. Here the court may say no. See here, someone has stolen the mobile of Katrina Kaif from the marriage ceremony. Then soon after the commission of the day, within 2 hours, it was found in the possessions of this Salman. Then as per section 114, the court may presume, what may presume, that Salman Khan has stolen that mobile, this fact. Okay. Or court may say no, because Salman Khan is such a rich person, he can't stolen a simple mobile. Okay. The court may, here the court has discretion presume or may not presume. If the court presume that fact as a proof, then initial legal burden which lies on the prosecution to prove that fact will not lie on the prosecution. On the contrary, to lie on that person against whom the presumption is held. He has to disprove it, and then there is a reverse burden of proof will lie on it. And second, if the court does not presume that fact, then initial legal burden lies on the prosecution as usual lies on the prosecution. I hope this what I thought may presume. So I am teaching you the concept of presumption first. What do you mean by presumption? There are two types of presumption: presumption of fact, presumption of law. Then we have discussed the difference in the presumption of the fact and presumption of law. Then now we are going to study section 4 of Indian Evidence Act, which defines three definitions: may presume, shall presume, conclusive. And right now I am teaching you may presume. So here again I read, whenever it is provided by this act, it means wherever in this act the may presume has appeared, there the court has a discretion. Court has a discretion. See here, that the court may presume fact, it may either regard such fact as a proof unless and it disproved, or may call for proof of it. Here the court may presume as a proof, or the court may say no, I don't presume that Salman Khan has stolen the mobile of Cat and Cape. I don't presume this fact. It means, friends, then the prosecution has to bring the independence and burden of proof lies on it. So these are the sections. In these sections of the Indian Evidence Act, they have used the word may presume. It means in this section, the court has a discretion. In this section, the court has a discretion, may presume or may not presume. And again, one thing is I am making clear that once the court presumes that fact, then that presumption becomes a shall presumption. That becomes the may presumption. So friends, let me know, have you understood the concept of may presume? If you have any query, first, again, I revise it. Here in the may presume, the court has a discretion to presume or not to presume. If the court presumes that fact, then initial legal burden, which always lies as usual on the person, does not lie on the person. On the contrary, it will lie on the person against whom the presumption is held, that reverse burden of proof, and may call for proof of it. The court may say, no, I don't presume that he has stolen the mobile of cat in a cave. Okay, the person has to prove these facts by bringing independent witnesses. So that is. तो यहाँ पे sections here section 86 to 88, 88A, 90, 98, 138, 140. In order to understand this concept, one should study the three sections 90, 139, 114 in order to understand this concept. Okay, so ये हो गया may presume. Now these are the section may presume. I will not go through it because it will take time to go through this concept. Now see section 114. Now I am going to teach you the section 113, presumption relating to men, the only death. Now there are, see, Indian Evidence Act deals with the presumption. See, there is one topic. There are three sections in Indian Evidence Act about a presumption relating to women. When it's someone's, please move someone, some voice is coming. Now, see, now there are three sections in Indian Evidence Act which deals with the presumption relating to men. One is section 113, another is section 113, and another third is section 114. Now, in respect of today's topic, now two sections are important, 113A and 113B. Now, this 113A comes in the May presumption. And wherever the legislature, the sections in which they have used the May presumption, there the court has a discretion to presume or not to presume. Now, when the question is, now you are preparing for family court judge, therefore section 113 is important for it. When the question is whether the commission of a suicide by woman had been abated by her husband or any relative of her husband, and see the first part. When the question is, when the dispute is, when the issue is, question is means dispute is, issue is whether the commission of a suicide by woman has been abated by her husband or any relative of her husband. Then the question is, if a woman commits suicide, whether her suicide was abated by her husband or any relative of her husband. You know, who comes on the definition of any relative of the husband? The Supreme Court interpreted relative means those who are the relative by blood, marriage, and adoptions. Only they come here, not this. Therefore, and see the first part. See the first part. Now, the first part, after first part, see the second part. It is shown that she had committed suicide. It is shown that. Now, the question is, what is the question is, what is dispute is, what is issue is? Whether a woman who commits suicide, whether her suicide had been abated by her husband or relative of the husband, then how can we assume it? How can we presume it? So here, now here, it is shown that she had committed suicide within a period of 7 years from date of her marriage. And one thing, when we may presume here, first, what the person has to prove that she had committed suicide within a period of 7 years from the date of her marriage, and that her husband or such a relative of her husband had subjected her to cruelty. Had subjected her to cruelty. And if she commits suicide, then husbands are liable under section 306 and 498A of IPC. Okay, therefore, sections 113A. I have prepared another chart there. There you will, I have prepared the chart of the 113A, 113B, 114A, through which we can study the how, with whom 113A should be read. Section 113A, read with section 498A, read with section 306 of IPC, section 306 of IPC. Now here, that her husband or such a relative of her husband had subjected her to cruelty. Now, section 113 is divided into two parts. First part, when the question is whether a whether a woman who had committed suicide had been abetted by her husband. Now, it is shown that three things. She committed suicide within the of 7 years of her marriage. Then, her husband or relative subjected her to cruelty. Now, what is a cruelty? Here, what is the difference in section 113 and 113b? In order to understand these two sections, 113a and 113b, one should understand the section 498 of IPC. Section 498 of IPC defines cruelty. An explanation defines the definition of cruelty. And the explanation of section 498A defines the cruelty. And there are two clauses, clause A and clause B of section 498. Friends, what I am telling to you, your clause A of section 498A read with 113A, read with section 306 of IPC. Section 306 of the IPC. उसके साथ में पढ़ना है. We have to read with the 306. See the sequence that I have prepared the diagram there, then you'll understand. So here see, in section 498A defines the offense of cruelty. And that section defines the definition of cruelty. And that definition has been given in two clauses. A clause and B clause. The A clause defines without any willful conduct. And B clause defines what is difference in clause A and clause B. This A clause of section 498A should be read with whom? Section 133. With whom? Section 306 of IPC. Why? Because that woman had committed suicide. Why? There was no demand of dowry. See, in clause A, willful conduct, no demand of dowry. In clause B, there is a demand of dowry. Then clause B of section 498A, read with section 113B, read with section 304B of IPC. Because there is a demand. In clause A of section 498A, there is no demand of dowry. There is only harassment. There is only ill treatment. Take the example, sometimes the in-laws torture that woman, married woman, that you can't cook, you don't know how to cook, you can't cook properly, you do not deliver the baby, okay? Then you do not clear the exam. So these are they taunt it, they nagging at each and every occasion without demanding any meaning. See, clause A of section 498A, okay, which defines definition of cruelty, there is a willful conduct, but without demand of anything. And if that woman commits suicide within a period of 7 years of marriage, then that is a presumption that they have abated her to commit suicide. Section 306. Okay, this is 138. Then here, what the court may presume? The court may presume, having regard to all other circumstances of the case, that such a suicide had been abated by her husband or by such a relative of her husband. The court may presume, having regard to all other circumstances of the case, that such a suicide had been abated by her husband or by such a relative of her husband. Now see example, by her husband or by such a relative of her husband. Now here, Once you prove these two paragraphs, the court may presume that her husband had been evaded her. Okay. On what basis? On this basis. So this is a section 113A. Here, for the purpose of this section, cruelty shall have the same meaning as in section 498 of the IPC. Section 498 of IPC defines the definition of cruelty in explanation. And I told there are two clauses, A and B. A without demand of dowry, B demand of money. Here neither section 498A nor 304B use the word dowry. They use the word cruelty. Okay, cruelty. Property or something. They have used the word. They have not used the word dowry there. Now here. So whatever the meaning is taken in section 498A, same meaning we have to take here. So again, please keep in mind, friends. The may presume is a reputable. If the court presumes, it is a reputable. See the definition of may presume. Whenever it is provided by this act, the court may presume a fact. It may either regard such fact as a proof. It may either regard such fact as a proof or may call for proof of it. See, in a may presume, the court has the discretion to presume or not to presume. If the court presume that fact, then if the court presume that fact, then burden of proof lies on the accused person to disprove it. There is a rebuttable presumption lies on him that we have studied. And if the court does not presume that fact, then initial legal burden as usual lies on the prosecution to prove that guilt, prove that fact beyond reasonable doubt. That we have studied here. Now, see, these are the essential conditions of the section 113A. I already taught to you. Now, then again, in order to understand the concept of may presume, one should go through the section 19, 113A and 114. We can understand this. So I already discussed all these things. So here, now I am going to teach you the shall presume. What is shall presume? Dear friends, let me know, have you understood the definition of may presume? Then I will proceed further. Have you understood this? Okay. What we have studied in a may presume? What is the definition of may presume? Whenever it is provided by this act, the court may presume a fact. Whenever it is provided by this act, the court may presume a fact. It may either regard such fact as a proof unless and until it disproved, or may call for proof of it. In a may presume, the court has a discretion to presume or not to presume. Okay, court has a discretion, court has a choice, court has an option to presume or not to presume. Then again, what we have studied, if the court presume that fact, then what are the consequences of it? If the court presume that fact as a proof, that Salman Khan has stolen that mobile, if the court presume that fact as a proof, then burden of proof, what is the correlation between presumption and burden of proof? Then burden of proof as usual, which lies on the prosecution to prove the guilt of the accused beyond reasonable doubt, will not lie on the prosecution. On the contrary, it will lie on the person against whom the court presumed that fact to disprove that presumption. That is called the rebuttable presumption. That is called the reverse burden of proof. Lie on the Salman Khan. He has to dispute that he has not stolen it. He has purchased the said mobile from the market by paying the fees proper amount. See this receipt. He may explain it. He may dispute. Then second may call proof of it. Means in may presume court at discretion. Either to presume as proved or not to presume as a proof. If the court presume that fact, then what happens? If the court does not presume that fact, then as usual, initial legal burden lies on the prosecution. And friends, again, what we have said here is start with whenever it is provided by this act. Whenever it is provided by this act means whenever the legislature has used the word may presume, the sections in which they have used the word may presume, there the court has a discretion. Section 86 to 88 ABC, then section 1998, then section 139, then section 114. In this section, you will find the may presume. It means in this section, the court has a discretion, choice, option to presume or not to presume. Okay? Sure. Okay. Now, I hope this is clear to you. Okay. Now, that is a shall presume. Next concept we are going to study shall presume. See, initially, I taught you the definition of presumption. Then we have seen there are two types of presumption, positive and negative. Again, we have seen we have classified the presumption two ways: presumption of fact, presumption of law. Okay, that we have studied it. Again, in section 4 of the Indian Evidence Act, defined three presumption: may presume, shall presume, conclusive proof. Now I have already taught you the may presume. Now the shall presume. What is shall presume? See, shall presume comes as the presumption of law. In presumption of law, we have seen this is an arbitrary presumption. It means here the court does not have discretion, choice, option to presume or not to presume because the law has mandated, the law has directed. In those sections, the court has to presume that fact. The court does not have choice. The court does not have option, but court has to presume that fact. These are called the arbitrary presumptions. Okay? Because the law has directed it. Now see the definition of shall presume. Whenever it is directed by this act, whenever it is directed by this act. See, in a may presume they have used the word whenever it is provided by this act. Here, whenever it is directed by this act, means this act means Indian Evidence Act. It means wherever they have used the word shall presume in the sections of this act, there the code has that the court shall presume a fact. The court shall presume fact, it shall regard that the court shall presume fact, it shall regard such fact as a proved unless and until it is a dispute. Now, we are studying three concepts: may presume, shall presume, conclusive. We already studied the may presume. May presume the presumption of the fact. It is a rebuttal. It is based on the logic. Now, shall presume comes under the presumption of law. It comes, it covers, it covers under the presumption of law. It covers under the presumption of law. And presumption of they are the arbitrary presumption. There, the court does not have discretion, choice, or option. It is a mandatory on the court to presume. See here, whenever it is directed by this act, whenever it is directed by this act. Now see here, what is the word? Whenever it is directed by this act. Means wherever they use the word in the Indian Evidence Act, wherever the legislature has used the word shall presume, there the court, there that the court shall presume fact, the court shall presume fact. It shall regard such fact as a proof. It shall regard such fact as a proof. Now here, shall, they use the word shall, means here the court has, it is mandatory on the court to presume that fact as a proof. In a shall presume, the court does not have discretion. Court does not have choice. From how can we understand that in a shall presume, the court does not have choice. The court does not have option because in a may presume they use the word either. It may either regard such fact as a proof or may call for proof of it. You will not find such a wording in a shall presume because they say whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as a proved. It shall regard such fact as a proved. Okay, it means here the law has made it mandatory on the court presume that fact. And but shall presume is a rebutable. Now see here, unless and until it is a dispute. Again, unless and until it is a dispute. Shall presume is a rebutable presumption. But it is an arbitrary presumption, court has to presume that fact initially. But a person against whom it is presumed, he may dispute it unless and until it is a dispute. Now, friends, which are the sections in the, wherein it has been provided, directed about the shall presume? See, sections 79 to 85, sections 85, sections 85B, sections 85C, section 89, 105, 111A, 113B, 114A. In these sections, you will find the word shall presume. In total, there are 17 sections. So friends, just we compare the shall presume with the may presume. In a may presume, the court has a discretion. In a shall presume, court does not have discretion. If the court presume that fact in a may presume, then that may presume become the shall presume. That become the rebuttal. That become the shall presume. Okay? In a may presume, the court has discretion. Shall presume, court does not have discretion. This that we'll see the another chart there. Through that chart, you'll understand each and everything. Now see it. So these are the sections 79 to 85, 85, 85B, 85C, section 89, 105. What is section 105? Negative presumption. 111A, 113B, 114A. We'll study the 113, 113B. Where is okay. Yes. Now here we are studying the presumption relating to men. Under the Indian Laws Act, presumption relating to men. There are three sections in Indian Laws Act deals with the presumption relating to men. One is sections 113A, sections 113B, sections 114A. Now section 113A deals with the may presume. Section 113B deals with the shall presume. Section 114A deals with the shall presume. 113A positive presumption. 113B positive presumption. 114A negative presumption. I told you there are two types of presumption, positive and negative presumption. Now see section 498A. Okay, now here, clause A of section 490, just I taught you 113. Presumption relating to men of abatement to come suicide. Now there, friends, under section 498A, section 498A deals with the offense of cruelty. And section 498A defines the definition of cruelty. The definition of cruelty has been given in two clauses, clause A and clause B. In a clause A, there is no demand of dowry. There is no demand of any money or any property. But in a clause B of sections, clause B of the definition of cruelty, there is a demand of dowry. There is a demand of property. Okay, now see here. If the woman commits suicide within a period of 7 years of her marriage, and soon, okay, and she has been subjected cruelty by her husband, then husband has committed the offense as per presumption, may presumption, under section 306 of the IPC, abatement to come. It means husband and relative of the husband abated her to commit suicide. That is a presumption there, abatement to suicide, then without demand of dowry. Here in section 113A, there is no demand of dowry. What is there? You do not look like good. आप दिखने को अच्छे नहीं है, आपको खाना पकाते नहीं आता है, पका दो वो बराबर नहीं आता है, आपको कपड़े धोने नहीं आते, आपको बर्तन साफ करने नहीं आते, आप जेएमएफसी पास नहीं होते, आप डिस्ट्रिक्ट की एग्जाम पास नहीं होते, आप फैमिली कोर्ट की जज की एग्जाम पास नहीं होते, आपको लड़के आपको अ, अ, आप आपको You are not giving the child to the birth. आप बच्चे को पैदा बर्थ नहीं दे रहे, या लड़की सिर्फ लड़कियों को दे रहे, आप दिखने को अच्छे नहीं है, ओके, उसको दूसरी शादी करना है, तो these are the example without demand in order to harass her, willful conduct. And if she commits suicide, then there is a abatement to commit suicide under section 306. Clause of section 498, read with 113, read with 113 of Indian Evidence Act, read with section 306 of IPC, abatement to suicide. Now, next, 113B, shall presume. There is a positive presumption. Read with clause B of section 498A, which defines the definition of cruelty. There is a demand. There is a demand. In order to meet the unlawful demand, okay, if she fails to fulfill the demand, and if she commits suicide by burn or otherwise, then only that clause B of sections 104, 498, read with 113B, read with section 304B of IPC. These are presumption relating to blame. These are the sequence points. See here. 304B IPC, there is called dowry death, is abatement to suicide, and here with a demand. Here there is no demand, here there is a demand in order to fulfill the unlawful demand. If he harass her, if he persecute her, okay, then and if she commits suicide by burn or other thing, then husband has committed the dowry in death. So these are the two sections, friends, about the presumption relating to me regarding the marriage. Here now I am going to teach you section 113, presumption as to dowry death. When the question is, when the dispute is, whether a person has committed the dowry death of woman, okay, dowry death of woman, and it is shown that soon before her death, this phrase is most important. Her death and her death and that this harassment, there must be a proximity. See, it is shown that soon before her death, such woman had been subjected by such a person to cruelty or harassment for or in connection with any demand for dowry. Here in 113, there is a demand for dowry. 113, there is no demand for dowry. The court shall presume that such a person had caused the dowry death. Then what court shall presume? Court shall presume that such a person had caused the dowry death. This is section 113B, presumption as to dowry death. What is dowry death? That is defined in section 3 of PV of the IPC. Now these are the two sections, 113A, 113B, about the presumption relating to marriage. Okay. Now, I am going to teach you the conclusive rule. It is very difficult to understand the conclusive rule. Now, let me know, friends. First, what we have just I have completed here, the shall presume. What is shall presume? Whenever it is directed by this act, that the court shall presume a fact, it shall regard such fact as a proof unless and until it is a dispute. Here, what we have studied in a shall presume, the court does not have discretion choice option, but it is a mandatory on the court to presume that fact initially. Okay? Then the person against whom the presumption is held, that person has to disprove it. उसने क्या करना है? Disprove करना है. Okay? So this is a presumption of shall presumption. In a shall presume, court does not have discretion. So this we have studied. And shall presume is a presumption of law. Okay. Now, next third concept we are going to study, that is a conclusive proof. यहाँ पे हमें कौन सा देखना है? Conclusive proof. Let me know, have you understood the definitions of shall presume? See, I am not feeling well, therefore my voice is not clear that much. और जो आवाज जो फ्लो होना चाहिए वो फ्लो नहीं है. Okay, now please reply. Okay. Now conclusive proof. Next third consider conclusive proof. See, we are studying here presumption. And presumption correlation, again, we are studying here presumption correlation between the presumption and burden of proof. I hope you understand this. Next, friend, again, we have studied the may presume, we have studied the shall presume, and now we are going to study the conclusive proof. Okay, it is very difficult to understand the conclusive proof, but I will simplify it and through the example, we will understand it. Now, what is a shall presume? Now here, now see what the definition says. The definition of conclusive proof has been divided into three parts. The first part, second part, third part. Now, what is it? When one fact is declared by this act. Now here, when one fact is declared by this act. See, I taught you two concepts, may presume, shall presume. In may presume provided, shall presume directed. And in conclusive, there is what declared. When one fact is declared by this act to be conclusive proof of another. Pehla fact. First, see the first paragraph. What the first paragraph says, when one fact is declared by this act to be conclusive proof of another. Friends, here there are two facts, one fact and another fact. I hope you got it. So what I told, the concept of conclusive proof is an irrefutable presumption. We have seen the chart. Concept of conclusive is a irrefutable presumption. One thing. And this definition of conclusive proof has been divided, I have divided into three parts. First part, second part, and third part. Now, here, when one fact is declared by this act, to be conclusive proof of another. Friends, after proving these two lines, we came to know कि यहाँ पे दो fact है. Here there are two facts, one fact and another fact. Now, this act declared, which act? This act has declared, Indian Evidence Act declared in these sections, 41, 120, 130. What? That one fact is declared by this act to be conclusive proof of another. Now, ये पहली fact, दूसरी fact को क्या है? First fact is relevant to, is not relevant, is conclusive proof to another. This is clear. One fact, when one fact is declared by this act to be conclusive proof of another. यहाँ पे दो फैक्ट है, वन फैक्ट एंड अनदर फैक्ट है. तो दिस एक्ट डिक्लेयर कि पहली फैक्ट क्या है, दूसरी को क्या है, सेकंड को क्या है, कंक्लूसिव प्रूफ है. क्या है? कंक्लूसिव प्रूफ है. नाउ हियर तो अभी क्या होना है, द कोर्ट शाल ऑन प्रूफ ऑफ द वन फैक्ट, द कोर्ट शाल ऑन प्रूफ ऑफ द वन फैक्ट. अभी देखो सेकंड पार्ट. नाउ सी, the court shall, on proof of the one fact, regard the other as a proof. देखो, here see, the court shall, on proof of the one fact. Once one fact is proved, not evidence, there is no proof. The court shall means mandatory, on proof of the one fact. अगर एक पहली fact prove हो गई, तो क्या करना है? Regard the other as a proof. तो पहला part, in first paragraph, what we have seen, there are two facts, one fact and another fact. तो one fact ये क्या है, दूसरे fact को क्या है, conclusive रूप है. Say what second paragraph says, the court shall on proof of the one fact. एक fact यहाँ पे prove होने के बाद तो क्या होती है, दूसरी fact prove हो जाती है. The court shall on proof of the one fact regard the other as a proof. एक fact prove होने के बाद उस fact से हम क्या करेंगे, दूसरी fact prove करेंगे. तो दूसरी fact prove हो जाएंगी, ऐसा मानेंगे. The court shall, on proof of the one fact, regard the other as a proof. कि पहली fact prove होने के बाद दूसरी fact क्या करेंगे, वो prove हो गई, ऐसा हम मानेंगे. तो पहली fact दूसरी fact को क्या हो गई, conclusive proof हो गई. Now third paragraph, and shall not allow evidence to be given for the purpose of disproving it. Now I told you that conclusive proof is a irrefutable presumption. How it is presumption? It is irrefutable, which we can't rebut it, which you can't disprove it, which you can't counter it. Therefore, it says if the first fact has been proved, okay, and on that first fact, you presume the proof of the another fact, then you are not allowed to disprove the first fact from which you presume the, from which you prove the prove the other fact. So this third line shall not allow evidence to be given for the purpose of disproving it. जो पहली फैक्ट है वो दूसरे फैक्ट को कंक्लूज हो गई, जो पहली फैक्ट यहाँ पे प्रूव हो गई, तो प्रूव होने के बाद यहाँ से क्या होता है, बराबर, तो दूसरी फैक्ट उससे क्या करते हैं, हम प्रूव करते हैं सेकंड थिंग। और तीसरा रूल क्या है यहाँ पे, जो पहली फैक्ट प्रूव किए वो पहली फैक्ट व्हाटएवर वी हैव प्रूव्ड हियर फर्स्ट फैक्ट, तो पहली फैक्ट यहाँ पे गलत है, ये हम क्या नहीं कर सकते, डिस्प्रूव नहीं कर सकते। shall not allow evidence to be given for the purpose of dispute. Friends, in order to understand the concept of conclusion, I will give the one example, and through the example you will understand. Preeti madam, please wait for some times. I will show that previous chart. Don't worry about it. Let me clarify the concept. अभी देखो, I will give the, in order to understand the conclusive proof, after perusing through this definition, you will not understand it unless I give the example to you. Now I give the practical example to you in order to attract your attention and concentration. Okay, now see the example. See the example. यहाँ पे देखेंगे example क्या है. You know the Malaika Arora. She had got married with the Arbash Khan. She had got married with the Arbash Khan. And she got divorced from the Arbash Khan on suppose on the 1st January 2023. 2023. Clear. And there the court recorded that Malaika Arora and Arbash Khan had got married on so and so day. And they were the husband and wife for a period of 18 years. Okay. Means till 31st December 2022, they were the husband and wife. On 1st January, court granted them divorce. Now they become the females with males. Now this is clear. Okay. Now what happened? The court gave the judgment in between them. That Malakarvan, they were the husband and wife. They had got on so and so date. Now on so and so date, their marriage was broken. Clear? Their marriage has been dissolved on 1st January 2023. It means before that they were husband and wife. Means this fact has been proved that Malaikar was the wife of the Arbash Khan till 31st December 2022 from the judgment. Now what happened? On 1st April 2023, she filed the, you know the Arjun Kapoor? Arjun Kapoor is no more. Suppose take the he is no more. And he has the children. He left behind his children, two children. Then this Malaika Arora filed a suit against the children of Arjun Kapoor, who is no more, who has died. What is suit? Suit for inherit the property of the Arjun Kapoor, being a widow of Arjun Kapoor. What she said? What she asserted? What she filed a suit against the children's heirs of the Arjun Kapoor? She stated that she was the wife of Arjun Kapoor. And being a widow of Arjun Kapoor, she had the right to inherit the property of the Arjun Kapoor. Now, the questions is here whether Malaika was the wife of Arjun Kapoor. Now, these children defend them. They get frightened. What happened this? Then what they do? They go to the family court where the court had granted divorce. They take the certified copy of the judgment which was in between the Arbash Khan and Malaika, and they filed that copy of the certified copy of the judgment in this case. And they pointed out to the court, see, that Malaika was the wife of Arbash Khan, and they had their marriage was dissolved on 1st January 2023. It means from this fact it shows that she was the wife of the Arbaz Khan. Okay, what did children do? They take the certified copy of the judgment in between the Malaika Ra and Arbaz Khan, Arbaz, in which they got the divorce. Now these children file the certified copy of the judgment in this suit, and they point to the court that that what was held by the court. They pointed to the court that she was the wife of the that Arbaz Khan. It means from this proved fact, it shows that she was not the wife of the Arjun Kapoor. Clear? See, when one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the one fact, एक fact prove हुई, what proof? That Malaika Ra was the wife of Arbaz Khan till 31st December 2022. It means, उससे क्या होता है? Regard the other as proved. वो fact prove करने के बाद other कौन सी fact है? Whether she was the wife of the Arjun Kapoor, it proves it means she was not the wife of Arjun Kapoor. Okay, ये fact से दूसरी fact क्या कर सकते? Once the prosecution proves this fact, once the party proves this fact, then from this fact the court regard the other as a proof. Means she was not the wife of Arjun Kapoor. Third fact, abhi third, and shall not allow evidence to be given for the purpose of discrimination. Here, Malaika Ra will not have right to give the rebuttal evidence. That she was not that Malaika, and that court had not given the proper judgment. That judge did not know anything about this. This is not a proper judgment. She cannot deny it. Okay, this is irrefutable. Shall not allow evidence to be given for the purpose of discrimination. Here, Malaika Arora will not have right to disprove that fact. What fact? That she was the wife of the Arbaz Khan. This fact has been proved. This fact she cannot deny it. Okay. So this is a concept of the conclusive proof principle. So here what I thought, the concept of conclusive proof has been divided into three parts. First part, second part, third. Only the first part, when one fact is declared by this act to be conclusive proof of another, the court shall, on proof, what proof? The court shall means mandatory, on proof of the one fact. What proof there? That Malaka Arora was the wife of Arbaz Khan till 31st December 2022. It means, बराबर है, on proof of the one fact, regard the other as a proof. What is a proof? It means she was not the wife of Arjun Kapoor. And then she will not have right and shall not allow her to disprove that fact. क्या? That she was the wife of the Arbaz Khan. ये गलत है, ऐसा है. She will not have right to disprove it. Shall not allow evidence to be given to the Malakara for the purpose of disproving it. It means that fact which has been proved by that court. So friends, here in this section of Indian Evidence Act, they have declared that these facts are the conclusive proof to another fact. So friends, I hope you understood this. So here you will see the one chart is there. I have prepared the one chart about the may presume, shall presume, and conclusive proof. At least it takes the 3 to 4 hours to teach this concept of the presumption. I taught you in a hurriedly. Now may presume, shall presume, conclusive. In a may presume, they have used the word provided. Shall presume, directed. Conclusive proof, declared. See, we have seen whenever it is provided by this act in may presume, whenever it is directed by this act, shall presume. When one fact is declared by this act, declared. How the hierarchy is there? Then may presume is a presumption of fact, shall presume a presumption of law, conclusive proof is a presumption of law, then may presume natural presumption, artificial presumption, conclusive presumption, and may presume is a discretionary. Means here the court has a discretion to presume or not to presume. And if the court presume that fact, then it becomes, shall presume, it becomes reputable. Okay? Here is a May presume is discretionary, shall presume mandatory. Here, the in a shall presume code does not have discretion initially. The code has a code. It is mandatory on the code to presume that fact. In a conclusive, mandatory. Here, may presume rebutable, rebutable, irrebutable. And in this section, they have provided. In this section, they have directed. In this section, they have declared that one fact is conclusive proof of another. And may presume is based on the logic. Shall presume is based on the law. These are unclear. It is uncertain because here the word a discretion. Uncertain. This is certain. This is a certain. Okay. So here they have used the word unless and until it is disproved or shall not allow evidence. Here they have used the word if the court presume that fact, may court shall presume that fact as proved unless and disproved. Here unless and disproved shall not allow any evidence to be given for the purpose of disproving it. So this is a concept may presume, shall presume, conclusive proof, friends. So here I taught you about these definitions. So now I got the whatever time I have been plotted. I tried my level best to teach you about this concept because it was not possible me to cover within short span of time. For instance. Yes, so today we are studying this concept of presumption, but that was not in detail. That was only superficial teaching was there. Okay, initially we are studying the definition of presumption, then classification of presumption, presumption of the fact, presumption of law, then positive negative presumption, then the chart of the presumption of that fact and presumption of law, then presumption rebuttable irrefutable. So that we will study here. I tried my level best to, because though I was not feeling well, my voice is not clear, but I can't vision it. Right? If you have any query, please let me know. आपको कोई क्वेरी होंगी तो मुझे बताओ. So do you have any query? No query. No questions. Madam, shall I wind up? Now, if you have any query, please take my mobile number 94231 94231 60612. If you require any my help for any guidance for oral, viva, something, then or if any questions about any concept of any evidence, CRPC, IPC, whatever subject you have, I will clarify. Okay, I will write my number. Hira Jadhav, madam, though I might, it will take 4 hours to teach this concept of the may presume, shall presume, conclusion. It is not so easy, but in a brief, I taught you. Yes, definitely. Please take my, I will write here my number. Because 94, please, will you take, will send me 94231 60612. This is my contact number. If you need any help, please, I will give you. Yes. Yes. Malakula sir, I wrote my number here. Madam, that Sawant madam, Rajashri madam has wrote my, thank you. If you need my help, definitely whenever I get time, I will deliver the lecture as per their convenience. Yes, yes.
Good evening.
Madam, yes, sir.
Thank you very much, sir. On behalf of Bar Council of Maharashtra and Goa, I extend my sincere thanks for such an elaborative session. Thank you so much, sir.
Thank
I
you.
request Sharad sir to please conclude the meeting.